Hello, I'm Jennifer McGuinness, a partner in the Contentious Trust and Probate team here at Myerson. I'm part of an 18-strong team, which includes 11 solicitors specialising solely in this practice area. Today, my colleagues Eleanor Clark, Katie Hayes and I are going to summarise 3 key topics that come up in our practice area and provide you with some of our top tips, which we hope you will find useful. Please note that these are very much a starting point and summary. So if there are any questions or queries that arise, please do reach out to us. We're happy to have a chat, and I believe our contact details will appear at the end of the presentation. So starting with myself, I'm going to talk about out-of-time applications under the Inheritance Provision for Family and Dependents Act 1975. So this is a large topic area that I probably could talk quite extensively about for a very long time, but you'll be pleased to know that today time doesn't permit. So this is very much a gallop through identifying key areas and summarising key points for you. As we have a mixture of practitioners in attendance today, I thought it'd be prudent to briefly go back to basics and address the nature of the Inheritance Act, which is often referred to as the 1975 Act or just the Inheritance Act. I don't want to teach anyone to suck eggs, but I do think it's helpful just for those who might not be as familiar with it, just to go through it. So the Act is a piece of legislation that gives the court the power to interfere with the sacrosanct concept of testamentary freedom, where it can be shown that reasonable financial provision has not been made for the applicant. The court doesn't interfere lightly with this, and as I repeatedly advise many new inquiries, the court doesn't have the power to do what one might feel is fair or morally right, such as providing for children equally or providing for family members over charities or neighbours, etc. The court is very much restricted to the powers that it's afforded by the legislation. Only certain categories of people can bring these types of claims, which are set out on the slide at the second bullet point. And if a person doesn't fall within one of those categories, they simply cannot bring a claim. But if an individual does fall within one of the categories, they are a qualifying applicant, but it doesn't necessarily mean that they'll have success. It's necessary for them to demonstrate that provision is required from the estate for their maintenance. The case of a spouse is slightly different, and my colleague Eleanor will deal with that later on. But we will look at the effect of the deceased will or the intestacy rules to see if they were unreasonable for the applicant. The court will then consider and balance various factors, which are set out in Section 3 of the Act, to then determine if an award for reasonable financial provision ought to be made. It is worth noting that receiving nothing under a will or the intestacy rules can be deemed to be reasonable financial provision. So what's the time limit for these sorts of claims? Well, this is set out in Section 4 of the Act, which again is detailed on the slide. And this section creates a statutory limitation period of 6 months from the date of the grant of probate or letters of administration. And this time limit was implemented for the benefit of personal representatives and beneficiaries to help give them clarity in administering estates and some security against claims in the future. So it's mainly there to give some guidance and help and to prevent them having concerns about claims coming in at later dates. The claim is made for the purposes of Section 4 by issuing the claim in court. So putting an opponent on notice about the claim isn't sufficient. It's necessary to actually issue a claim in court within the 6-month period. Now, 6 months is a relatively short period to get any claim ready for court proceedings. But when you get instructions within that 6-month period and right up against that limitation date, there really is a frantic scurry of activity to make sure that the claim is ready. But what happens if you're not ready and the claim is out of time? Can you still proceed? Well, the answer to that question, by reason of Section 4, is yes, you can proceed out of time if you miss the statutory limitation period. You're offered a lifeline, but you do require the permission of the court to be able to bring the claim out of time. So an application has to be made, but it cannot be assumed that it will be given. In many cases, it isn't. And a bit like the Section 3 factors of the Substantive Act, there's a host of matters that the court will consider and balance in determining if a claim can proceed out of time. These aren't set out in statute, but they're set out in various cases. And the 2013 case of Berger v. Berger is particularly helpful as it set out 6 key considerations that the court will consider, but pointed out that none of these particular factors are determinative. The court will balance all of them. And the factors that were set out were as follows. It's the length of the delay, the reason for the delay, whether the estate has been distributed, whether there's merits in a case, and that's quite a low threshold, an arguable case, or a case that's more than mere fanciful will often be deemed to be okay. if there's any prejudice caused to the other parties by giving permission, and the promptness of the application. Now, as I said, none of these factors are determinative, they're all balanced, and essentially each application turns on its own facts. There's also no threshold as to how long is too long on a case like this. The court's got very wide discretion and will consider matters on a case-by-case basis. But what the case law does show is that judges consider the balancing factors in detail, meaning that in some cases there have been very long delays and the claim has been permitted to proceed. And similarly, there's been short delays where the case has not been able to proceed. I've set out on this slide some cases, giving some brief examples of applications that the court have asked to be considered. Berger and Berger is one that I've already just mentioned. This was a claim that was 6 years out of time, and that application was unsuccessful. 6 years was considered to be a lengthy delay. The estate had been distributed, and there'd certainly been a lack of promptness on the part of the lawyers and the parties to move things along quickly. And for that reason, the court dismissed the application. A case that raised many eyebrows at the time was the case of Probate and Patel, where an application was granted where the application for permission meant bringing the claim 25 years after the limitation date. I think if that had crossed my path, I probably would have said, you've got no chance. But ultimately, there were really good reasons why the claimant in that case couldn't bring her action any earlier. She had absolutely no financial provision from her husband's estate. The lady in question didn't speak English, didn't read or write English, and wasn't able to bring the claim. She had no idea about the English jurisdiction. And also, there had been no real administration of the estate that would cause any prejudice to the parties. So for all of those reasons, that claim was permitted to proceed out of time. Cowan and Foreman is a case that's often talked about. On first instance, the application to proceed out of time was dismissed, notwithstanding that the parties had agreed between themselves not to raise the issue of delay, and that they were in advanced negotiations to try and settle the case. Ultimately, things fell apart and it became necessary to issue the claim, and the court would not grant permission, notwithstanding the activities of the parties during that period. That decision was overturned on appeal, which in my view was the right decision, given that the parties were engaging and were fully aware of the circumstances. That case was also interesting because the estate had been administered, but only in part, and the court pointed at appeal that the fact that there were sufficient funds left in the estate to meet a claim was a determining factor. We've had quite a few recent examples in our own team of these types of applications, all of which I'm happy to confirm we've been successful in. Indeed, Katie, who you'll be hearing from after me, was in court just yesterday on an out-of-time application on behalf of the deceased minor daughter. This claim was just over 12 months out of time. There were good reasons for the delay. The client's mother had laboured under a misapprehension that her daughter was going to benefit from a life policy, and therefore she probably wouldn't need to bring any sort of claim. But ultimately, that didn't transpire. And so she took some advice. By the time we were instructed, the case was significantly out of time, which I'm sure Katie will explain that she was caused her a great deal of stress to try and get that over the line. But ultimately, she got in an application really promptly, which was commended by the court yesterday. And upon balancing all of the factors detailed in the Berger case I mentioned earlier, the court was satisfied that permission ought to be granted. So we are really pleased with that result for Katie and for our client. So ultimately, what are the prospects of success if you need to bring an application of this nature? So if an application is made, are you going to be successful or not? Well, flippantly, I could say it depends on which judge you get. But generally, the factors set out in Berger and Berger will speak for themselves and ought to be able to give you a good indication. But essentially, you can consider prospects to be in the good category if the delay is short, there's a good explanation that you can give, and you've taken prompt action to bring the application, supported by a strong claim and the fact the estate has not been distributed. This is your gold standard sort of application. And I suppose in some respects, that's probably where Katie was yesterday, although I would suggest that the delay of 12 months isn't what you might consider a short delay. It is a long delay, but there were good reasons. Things do get a bit nervy where there's a longer delay, but if there is a good justification and a decent arguable claim can be made and there's money in the estate, no prejudice to parties, then we probably suggest that success rates are in the moderate category. So a little bit more uncomfortable, but still worth making the application. If, however, as in the case of Berger and Berger, the delay is lengthy, cannot be reasonably justified, prompt action hasn't been taken, the estate's been distributed, and the case is merely fanciful, the prospects are not going to be good, and it would not be advisable to apply for permission. Indeed, if an application is brought for permission and fails, it is likely that a cost order would be made against the losing party. In practice, cases don't really neatly fall into those three boxes. There are often big swathes of grey areas in between, and so we're not able to be definitive, but generally the factors do help us assess whether we think it's worth making that application. So that leads us on to the top tips in these types of applications. And given Katie's success yesterday, I probably should hand this one over to her. But my experience of these types of applications, I think promptness is really crucial. And that's probably my go-to would be act as quickly as you possibly can. And that applies to the applicant themselves. They should be getting legal advice as soon as they possibly can. And the lawyer who's alerted to the out of time aspect should also be acting as quickly as possible. So if an application is to be made, I'd really recommend a chronology of what's happened, what action's been taken, and when that action was taken will be pored over by a judge. So you need to be able to demonstrate the speed of response. And in that respect, your file notes, emails, and letters will be crucial evidence, which you will likely want to append to your application. So be aware of that at the outset. Make sure that they are contemporaneous and that they're detailed, and keep copies so that they can support your application. Secondly, I'd say a detailed explanation for your reasons is going to be required, and that's going to be explored in some detail. So you need to get as much information from your client as possible as to why there has been delay, why haven't they acted more quickly, and if there's any evidence available to support that, then include that as well. So keeping a step-by-step chronology or timeline, again, is a really useful tool that's going to assist both you and the court. Helping the court is another tip. I do think that the more you can do to help a judge by addressing factually and succinctly the factors that the judge needs to consider will make his or her job an awful lot easier, and they will thank you for that. So we really recommend that we are dealing factually with the matters that arise by reference to the factors as set out in Berger v. Berger. I also think it's helpful to demonstrate that the applicant has no other remedy and no other course of action that they could bring, so as to demonstrate that it's important that they can bring this claim, because otherwise they're left without a remedy. So by that, it might be, for example, that if the client has previously taken legal advice or sought to explore this but was given bad or incorrect advice, or that solicitor delayed, then that client might have an action in negligence rather than seeking permission of the court, and if so, they should follow that route. So you need to demonstrate that the court that there isn't any other route, there simply isn't another route. This is the only way that your client is going to get the remedy. The next point I'd like to make is that judges are really turned off by emotive language and irrelevant history. Things like he said, she said type of information can make things really difficult and cloud the real issues. As I say, judges just want the facts. Now, this can be really difficult in managing your client, because these are all the important things on a human level, and they're things that your client will undoubtedly want to get across. But it's really important that they're well guided, and that you're bold and ensure that the information that you're providing to the court is relevant and succinct and isn't clouded by the emotive aspects of it. Judges can't make decisions based on emotion or what an individual considers might be fair, because they're constrained by the powers of the Act, and therefore they very much appreciate it when your application is limited to the factual information that they need to make the decision. Another issue that I think is worth noting, and it's something that Katie used to good effect in her application ultimately, was that don't look past specifically asking your opponent if they will agree not to oppose the application. Now, an opponent can't consent as such because it's not within their gift. The court has to give permission for these types of applications to proceed. But what an opponent could do is say, we're not going to actively oppose your claim. And on that basis, you're going to save the court a lot of time, you're going to save a lot of cost, because it would be unlikely for a judge to refuse permission if all parties are in agreement. So I certainly think it's something that often does get overlooked. But I think the court would look kindly on the fact that you have asked. The other point being it if your opponent is particularly difficult about it and their conduct becomes an issue, there could potentially be an argument that you ought to be able to recover your costs for the application if you are successful. So I certainly think that it's worth making that inquiry with them at the earliest opportunity and putting them on notice that you are going to make the claim. So overall, they are my top tips for these types of applications. As I said earlier, if you have any questions at the end, please do get in touch, and I will hand over next to Katie. Thank you.
Okay. Hi, as Jennifer said, my name's Katie Hayes and I'm an associate solicitor here at Myerson. And during today's presentation, I'm going to do a whistle-stop tour of Lark v Nugas requests. So we'll have a brief look at the purpose of a Lark v Nugas request, consider when solicitors should respond and when they can be encouraged or compelled to do so, provide an example of a best practice checklist for practitioners who receive a Lark v Nugas request, and assess the possible risks of failing to reply, including the cost consequences. So what is a Lark v Nugas request? Essentially, a Lark v Nugas request is a letter sent to a will drafter asking for information and documents contemporaneously prepared, which shed light on the testator's intentions when preparing his will. Such documents may include attendance notes, emails, instructions, and/or a complete copy of the will file. More often than not, requests will also include direct questions to the will writer. For example, where capacity is in question, did you consider following the golden rule? I.e., if you had any doubts as to testamentary capacity, did you seek the opinion of a medical expert? If not, why not? What in particular caused you to reach the conclusion that the testator had testamentary capacity? It can be unnerving to receive a Lark v Nugas request and can sometimes feel like your professional decision making is under scrutiny, but ultimately, a Lark v Nugas request is simply an effort to investigate the circumstances surrounding the execution of the will, quite possibly because the contents are unexpected or surprising to a family member. The more helpful you can be at an early stage, the more efficiently the matter can be dealt with, and the less likely you are to be caught up in hostile litigation. The Law Society have set out some helpful guidance on how to respond within their guidelines, and I think the link to which is going to be detailed on the slide. So what's the purpose of a Lark v Nugas request? As I said, Lark v Nugas requests are an investigatory step in considering the validity of a will and are designed to encourage early resolution of disputes, avoiding unnecessary and fanciful probate litigation. When we're investigating the validity of a will, it's often our first point of call. We'll obtain a copy of the will, file, and potentially have a look at medical records. This is usually enough evidence to advise the client on whether we consider there is merit and value in pursuing the claim further. So when we receive a will file, we're running through a bit of a checklist in our minds. So number one, we'll have a look whether the will appears to be validly executed. Were the Section 9 requirements met? 99 times out of 100, where the will's been executed with the professional will writer present, it's going to be validly executed. If the will's been drafted by a professional, but the testator has taken it away to execute it, we might be looking at the instructions given by the will writer in respect of execution. Is there a letter explaining the requirements of Section 9 that can be relied upon to show that the testator was aware of those requirements? If we're looking at whether the testator had testamentary capacity, we'll consider the Banks v Goodfellow test and whether there were any discussions touching upon each limb of the test recorded within the notes. For example, the testator knew that he had a mortgage-free home worth £400,000 and £150,000 in the bank to evidence that he was aware of the size and nature of his estate. We'll also look at the wider indications of capacity. Is there evidence that the testator was appropriately dressed for the meeting or that they were able to hold conversation and eye contact without becoming distracted? Did they make appropriate small talk? Did they greet the will writer in an appropriate manner? These are all wider indications of testamentary capacity and are worth noting when instructions are being taken. Thirdly, was the opinion of a medical expert sought, and if so, is there a thorough instructions letter asking the expert to touch upon each of the Banks v Goodfellow limbs? Have we got a copy of the medical report, or do we need to see a copy of the medical report? And if we're considering whether the testator may have been unduly influenced, we're looking at evidence of vulnerability and to some extent control. Did another person make the appointment for them? Did they bring them to the appointment? Did they come into the room when instructions were being given or speak for them? Did the testator depart from a previous will-making pattern? And if so, did they give a sensible explanation as to why? Did the testator give any instructions that may have come from somebody else? For example, I'm disinheriting my daughter because she has repeatedly told my son that she doesn't care about me and thinks that I should move into a care home. That's quite an extreme example, but mentions of family dynamics and reasons for departing from previous wills are key in these kinds of disputes. The court do place a high regard on the assessment of will writers and their contemporaneous notes, which really can be key in determining the outcome of a dispute. The more information the will writer is able to provide in support of their assessment, the better. The more thorough the notes at the time of preparing the will, particularly where a testator is elderly, frail, or seemingly disinheriting a child in favour of another, the easier it is for all parties to understand the reasoning behind the will. Do solicitors or will writers have to respond to a Lark v. Nugas request? The short answer is there's no legal obligation to respond to a Lark v. Nugas request. However, the Law Society do strongly recommend that response is provided in circumstances where the request cannot be easily dismissed as a fishing expedition. The case law surrounding Lark v. Nugas requests, and we'll come to have a look at a particularly important recent case shortly, suggests that the courts are more willing than ever to criticise will writers for obstructing investigations, and cost consequences can follow. The courts are very keen to crack down on unnecessary litigation and are continuously introducing measures, such as the October 2024 changes to the civil procedure rules to include provisions for mandatory alternative dispute resolution in order to do so. Personally, I think we'll see more and more cases where will writers and or personal representatives are penalised for failing to respond to Lark v. Nugas requests properly or in a timely manner. Confidentiality and privilege. So, given that these disputes arise when a testator is already deceased, can the will writer simply disclose the information without consent? Again, the short answer is no. The will file remains privileged, and that privilege belongs to the personal representatives. A blanket refusal to disclose information in unreasonable circumstances does run the risk of an adverse cost order against personal representatives, so they must be consulted. The Law Society also provides helpful guidance on what to do where there is a dispute as to who the executors are, and states that the best practice is to seek consent from all potential personal representatives. Ideally, personal representatives are reasonable in the circumstances and agree to disclosure without much difficulty. But what happens when they don't? There are some legal routes to compel disclosure. There's three possible options when considering how to compel disclosure of a will file or information pertaining to the instructions of a testator. Number one, Section 122 of the Senior Courts Act 1981. The court can order a person with knowledge of a testamentary document to attend court for examination. The court can also compel the person to answer questions about the document. Section 123 of the Senior Courts Act 1981, the High Court may issue a subpoena requiring production of a testamentary documents. And finally, CPR 31.16, which is our pre-action disclosure. Applications pursuant to CPR 31.16 will be granted where it may assist in disposing fairly of anticipated proceedings, assist resolution without proceedings, or save costs. All of the options listed on the slide come with a high risk of an adverse cost order where the information has been refused previously. So it's really important that these risks are explained to the personal representatives. Where personal representatives refuse to permit disclosure, the will writer's advice to them should be recorded clearly and set out in writing to ensure that they're covering all bases and protecting themselves. So coming on to the recent case law, the case of Addison v. Niaz, which was a 2024 judgment of Chief Master Schumann. The High Court ordered a solicitor who drafted a disputed will to pay the applicant's costs due to a significantly delayed and inadequate response to a Lark v. Nugas request. The solicitor's poor response, which was slow and incomplete, forced the applicants to apply for a court order. The court considered that the delay of over 3 months was lamentable, and the solicitor was ordered personally to pay £5,729.40 in costs. So it's clear the courts are willing to come down hard on solicitors and will writers who will not assist with the initial investigations in order to promote the early resolution of disputes. Failure to do so carries substantial cost risks. So what is the best practice checklist or an example of if you are to receive a LARC v Nugus request? Number one, I think it's important to assess the seriousness of the potential claim. Is this a fishing expedition? Can you justifiably push back? Or at the very least, the seriousness of the potential claim needs to be discussed with the personal representatives, and it should be considered whether they require separate legal advice. Then we go on to consult the personal representatives and request their consent, as we've previously discussed. Then we want to review our file of papers. Does it jog your memory of the test data? If there's any direct questions, is there evidence in the file that might help you provide an appropriate response to those questions? Consider, can you reply by the proposed deadline? If not, perhaps send a letter or an email explaining why and offering an alternative timeline. We say 14 to 21 days is an appropriate timeline to try and stick by. Then prepare your witness statement, which is likely to address direct questions and may take the form of a list, and cross-reference with the contents of the will file. It's always important to bear in mind that you could be asked to repeat the contents of your statement or the replies to any questions on a witness stand. Then we need to redact carefully and consider any privileged information, which we've already discussed. And then finally assess whether there is a risk of negligence and put your COLP or insurers on notice if there is. Next, the important matter, charging for a response. The SRA Code of Conduct does not prohibit solicitors from charging reasonable costs for producing the information. The key word is reasonable. Fees must be justifiable when considering the hourly rate of the will writer, the work that can be done by administrative staff, such as printing off the will file and redacting confidential information. Fees should be reflective of that. It's best practice to give an estimate of cost to the person sending the letter or request. It might even assist to give a breakdown of how long you consider it will take to respond. If a party is investigating the validity of the will and does not wish to incur the disbursement, they could offer to pay an administration fee and seek the will file only, disregarding the need for an accompanying statement or replies to questions. This is a tactic we employ often, and upon receipt of the will, we may choose to encourage a client to seek a formal statement and incur the disbursement, or we may consider that the evidence is sufficient in itself to determine whether it's worth pursuing a claim. So a summary and recommendations. Upon receipt of a LARC v Nugus request, there's no legal requirement to respond, but it is certainly best practice to do so. Refusal to do so or delay in responding may well result in personal cost liability or put the personal representatives at risk of a personal cost liability. The courts do have the power to compel disclosure. They're not afraid to use it, and the risks associated with an application should be very clearly set out to the personal representatives. Where personal representatives refuse to disclose the information, the advice to them should be set out clearly in writing so that the same can be replied upon in the event an application is made. All in all, it's most definitely worth responding as fully as possible unless a will writer considers that there is a risk of professional negligence claim, in which case it should be discussed with the COLP and potentially separate legal advice obtained. The best way to prepare for a potential LARC v Nugus request, particularly with challenges to the validity of a will on the rise, is ensure that thorough contemporaneous notes are kept at the time of drafting the will, particularly if any alarm bells were ringing, such as you have concerns about testamentary capacity or the testator is disinheriting somebody who would usually expect a benefit. It's then just a case of referring to those notes and compiling a response should the request come in. And as I said, receiving a LARC v Nugus request can be concerning and it can feel like a bit of a question mark over your professional judgment. But primarily and particularly in the first instance, it should be treated as a mechanism for parties exposed to a potential dispute to reach an early resolution in accordance with the overriding objective of the civil procedure rules. If you do receive a LARC v Nugus request and you're unsure on what to do or where to go next, we are a friendly team and we're always happy to have a chat. So do reach out if you want to discuss anything further. So that's all from me. So I'll hand you over to Eleanor, who I believe is discussing spousal claims pursuant to the Inheritance Act.
I'm Eleanor Clark, and I'm going to talk about reasonable provision for a spouse in relation to claims under the Inheritance Provision for Family and Dependents Act 1975. So my colleague Jennifer addressed claims generally under the Inheritance Act and how we deal with bringing these claims out of time. So I'm going to look at one specific category of claimant, that's a husband, wife, or civil partner who's left behind when their spouse passes away. We normally refer to this category of claimant as a surviving spouse. Obviously, there's a clue in that it's a separate section of the talk, but a spousal claimant or a widow is treated quite differently under the Inheritance Act than other types of claimant. And so when someone passes away and doesn't make reasonable financial provision in their will for their spouse or civil partner, then they can make an application to the court for financial provision from the estate. So as I mentioned, there are various categories of claimant, and the claims that they can bring against the estate of someone that's passed away are assessed differently depending on what category they fall into. Spousal claims are considered in a different way in that they don't have to prove that they have a need for maintenance from the estate, and instead their claim is for what would be reasonable in the circumstances of the case for a husband or wife to receive, even if they don't require specific provision for their maintenance. As a general point, a testator can't exclude a claim under the Act in their will, and no amount of clever drafting or sensible advice can make a will bulletproof against a claim, especially in the case of a surviving spouse, where there's significantly more willingness by the court to interfere with the testator's testamentary freedom and override the wishes of the testator to make provision for a spouse. The phrase reasonable provision is obviously quite vague. So in order to assess this, the court will look at a variety of factors, which we refer to as Section 3 factors because they come from Section 3 of the Act. And these are the factors that are considered in all cases, not just in spousal claims. So firstly, they are the financial resources and financial needs which the applicant has or is likely to have in the foreseeable future. So what the court would hope to achieve is a sort of snapshot of an individual's financial circumstances and what they might need both now and in the future. Then the court would also look at the financial resources and needs for any other applicant under the Act. So maybe an adult child, or we've seen other spousal applicants, potentially other partners of the deceased, anyone else basically that's making a claim against the estate. And then they'll look at the financial resources and needs of any beneficiary of the estate, so the people that would benefit if not for the claims against the estate. And then they'll look at the obligations and responsibilities which the deceased had towards any applicant or any beneficiary. So often that will be dependent children or someone of that nature. Then they'll also look at the size and nature of the net estate. So basically a key factor is obviously what assets there are in the estate, what resources there are, and whether they're able to meet the needs and the claims that are being put forward. Then they'll look at any physical or mental disability of any applicant for an order. So this will obviously tie in to the other factors, so the financial resources and financial needs, because potentially a physical or mental disability might lead to increased needs or reduced resources. So all these factors are taken into account together. And then lastly, there's a sort of any other matter, including the conduct of the applicant or any other person. One word of warning in relation to that is often clients will want to raise a number of conduct issues that they think should be brought up and are quite important. In our experience, it tend to have to be quite extreme conduct examples for that to be given very much weight by the court. So that can be disappointing potentially for clients who think that there are a lot of conduct issues they'd really like the court to hear about. So on to the next slide. In terms of additional factors, there are specific factors that are taken into account in the case of spousal claimants. And these factors are related to the considerations looked at by the court when the parties divorce. So if you were looking at a division of assets on divorce rather than death. And these considerations come from Section 25 of the Matrimonial Causes Act 1973 and are relevant to the Inheritance Act. And specifically set out there. They are the age of the applicant, the duration of the marriage, and then the contribution made by the applicant to the welfare of the family, including any contribution made looking after the home or caring for the family. In terms of the length of the marriage, there's no specific definition, but in general, case law suggests that a marriage of 5 years or less is considered a short marriage, 20 years or more is considered a long marriage, and anything in between can be medium. But there's not, it's very case specific. So any period of cohabitation before the marriage can also be taken into account. So if the parties have lived together for a long period of time, as if they're husband and wife before getting married, then even if the actual period that they were married is relatively short, then that cohabitation will still be taken into consideration and can make it so that the marriage is treated as a longer marriage than the actual dates might suggest. In relation to the contribution to the family, this isn't limited to financial contribution, and there's normally no distinction between the financial contribution and the domestic contribution of the parties. This, in my experience, can be quite difficult for family members to recognise, particularly if they feel that their parent has contributed more financially to the marriage, potentially brought significant assets to the marriage. And they can feel very frustrated at the thought that they might have to sort of give those up, or aren't able to just pass those on in the way that they would like to in their will, because the contribution of the other party, the spouse, might be a domestic contribution, could be a caring contribution or something of that nature. And I think that sometimes we certainly see in defending a claim, people find that quite difficult to recognise. As you probably realise from the previous slide, these factors tie into the overlap in relation to family law provision and what would be considered on divorce. So in general, when a settlement is made, an award made to a spouse in the Inheritance Act, it's assessed against the divorce cross-check, which generally means that the claimant should not be worse off in respect of what they get under an Inheritance Act claim than they would have been if the marriage had ended in divorce rather than the death of their spouse. This is helpful, I think, probably when people are making a will to consider, because I think there's a general awareness amongst clients that if they were getting divorced, they'd have to give up a substantial proportion of their assets. And I think even potentially that could be an equal division of assets if they were getting divorced. But I don't think there's necessarily the same awareness that there is on death. So it's something to flag up at the point of making a will if you're dealing with people who are wanting to leave minimal provision for a spouse, or not wanting to make provision for a spouse at all. It's also worth noting that the divorce cross-check is not a ceiling or a floor, so it doesn't mean it's the only order the court can make. Particularly in the case of an Inheritance Act claim, it's obviously very different to a divorce, in that one of the parties has passed away, so there's only one party to maintain rather than two. So potentially, particularly in smaller estates, this can mean that the claimant could expect to receive more than they would have done on divorce, as they can have potentially an award of assets to meet their needs, whereas on divorce, those needs would have to be balanced against the needs of their spouse and shared between them. So certainly something worth highlighting, and potentially talking through with someone who's wanting not to make significant provision for a spouse in their will. One of the things that we see considered a lot and argued about a lot is the matrimonial pot and what this might consist of. So when we're sort of setting out the basic situation to clients, we would normally say we look at the matrimonial pot, the assets owned by both the parties, and these are considered and then divided. So that's quite a basic interpretation of what the court would look at, particularly when you get to sort of second or third marriages. A lot of assets could be owned before the marriage, brought to the marriage, held differently. And we often see that family members defending an Inheritance Act claim will argue that assets shouldn't constitute part of the matrimonial pot, because they were owned before the marriage, or sort of came from a previous marriage or something of that nature. It's not a straightforward calculation of whether they will be taken into account or not, and it very much depends on how those assets have been treated during the marriage. Even if the assets weren't owned before marriage, before the parties got together, whether the assets constitute part of the matrimonial pot can change during the course of the marriage, depending on how the assets have been used. On the flip side, if the assets have genuinely been left alone and not used during the marriage, not benefited from during the marriage, then there could be an argument that they don't constitute part of the matrimonial pot, but it's not straightforward. So certainly something that's worth taking specific advice in relation to. And also an additional warning might be that if the surviving spouse has particular needs that need to be met financially, such as care needs or something of that nature, then they might be able to access those funds anyway, even if they're not deemed to sort of traditionally be part of the matrimonial pot. It is a difficult one to advise in respect of someone making their will, because, as I mentioned, the treatment of the assets can change, and that might well change in between making their will and the time that they pass away. So you couldn't necessarily guarantee that would still be the case on death. Also, the circumstances of the surviving spouse might well change. It might be that they do have significant needs by the time their husband or wife passes away. So it's something to be aware of, really, rather than something that you can necessarily provide specific advice on. But it's definitely something to flag up and to take into consideration. In respect of other common issues, and this is obviously a quite brief overview of the things that we deal with. But short marriages is something that comes up a lot, where the sort of family of the deceased argue that if the parties haven't been married for very long, the claimant shouldn't receive significant provision. This can be a difficult aspect to advise on. It can be different to the treatment on divorce, as we do see some cases where someone has died suddenly at a relatively young age, not expected, and it's not the party's choice to have a short marriage. It might well be that they had every intention of remaining married for 30 to 40 years or whatever. And certainly in cases I've seen, that is treated differently to the potential division they might have got on divorce if the parties have been married a very short time and then decided to get divorced. But I think the bottom line is that if the parties are still married, then it's something that they will have to deal with. The length of the marriage is a factor you can argue, but it's not something that you're going to get away without making reasonable provision for them. Another aspect is the financial position of the beneficiaries. I touched on this earlier, but basically it's going to depend on what their situation is at the time they make the claim rather than when the will was made. It might be that provision was reasonable when the will was made, and then that moves on, and by the time that the spouse passes away, the provision is no longer reasonable and doesn't meet their needs. Again, difficult to predict or advise upon, more something to be aware of because you obviously don't know what the situation is going to be. Another common issue is the lifestyle enjoyed by the deceased and the applicant. Again, this is something that's taken into account by the court and something that in practice I see a lot of sort of criticism of or difficulty in dealing with for people defending claims. Quite often, and certainly seen it in a number of cases, we will see family members who say that a spouse came to the marriage with nothing. It didn't have a particularly sort of affluent lifestyle before the marriage, clearly enjoyed a nicer standard of living during the marriage, and they don't see why that should be maintained. They think they should go back to whatever they were happy with before, because it's not their sort of financial assets that they've brought to the marriage. Certainly in my experience, that's not how the court would see it. They would look at the standard of lifestyle that the husband and wife had while they were married. And so another thing to flag up to say this is going to be taken into account. Another complicating factor can be the impact of the death on the balance of the available resources. This can obviously have an impact in various different ways. If, say, the person who's passed away was still working, then it can destroy a source of an income stream, which could be a consideration as it would have been part of their assets. But it can be that the death also creates a value in the form of a life insurance policy, a death in service benefit, or a guarantee payment for a personal pension or something of that nature. So all of this will be taken into account in terms of when the court look at the surviving spouse's financial circumstances. Even if they've received a payment from a pension that falls outside the estate, that will be taken into account in relation to their own finances when the court will look at the division of assets. In terms of top tips, in general, would be to advise anyone making a will of the possibility of a claim under the 75 Act if they're not making substantial provision for a spouse or civil partner. If they are adamant that they still don't want to, then it would be worth just flagging up that this is an issue and potentially advising them to speak to their children about a potential claim. The only reason I mention that is I think we see a lot of claims where children obviously recently lost a parent. They're then faced with defending a 75 Act claim. And this is, you know, the time when they come to see us is probably the first time they've ever considered that there could be this kind of claim. They'd have no idea that this type of claim was even contemplated. So even if someone is adamant that they don't want to make provision for a spouse, if their children or whoever might be defending the claim is aware that it could be a potential claim, then I think that might make it easier to deal with rather than having to deal with it all at once while also grieving for their parent. Definitely worth flagging up the divorce cross-check and just an awareness that the only way of excluding a claim under the 75 Act is by financial settlement order on divorce. We do see cases where the parties are in the process of separating or divorcing, but there hasn't been a final order. So even if there have been those negotiations in the divorce, if there hasn't been a final order, there'll still be the potential claim under the 75 Act that will still have to be dealt with. And the claim will continue as a 75 Act claim rather than as the divorce. Generally, that was obviously a very quick whistle-stop tour of the various issues. They're not simple matters to deal with, so we'd advise anyone with a complicated family situation or complex assets to take as much advice as possible. Potentially consider consulting a contentious probate solicitor as well at the time that they make their will if they think that there is likely to be a claim and whatever they want to do in their will is likely to be controversial. It's worth pointing out that if there is an acrimonious separation or divorce or something of that nature, then this will be passed on to their grieving relatives. So we've, you know, if even if they're saying, oh, I'm in the process of getting divorced, I absolutely don't want to leave her anything or him anything, they are effectively setting their family up for potentially years of litigation, and they're going to have to deal with that and grieving at the same time. So while they might not want to leave reasonable provision to their spouse, they almost certainly don't want to leave it to me or any of the other lawyers involved. So that's definitely something that's worth taking into account as well. So all in all, that was very brief. As Katie mentioned, we're a friendly team. If you've got any concerns or questions at all, then please don't hesitate to contact us. Our details will be on the slide, and that'd be lovely to hear from you.